Greetings, everybody. We are about to get started. So for all of you that are on, if you can Facebook me, those of you on Facebook, I know a majority of people taking the course are not on Facebook, which is okay. We'll get you there someday. If you guys can chime in with me, let me know that you're seeing the stream and everything is good, please. Thank you very much. We'll get started in about 1 minute now, 60 seconds. I suppose it's much warmer down there in Florida. Hope things are going well for you, Chris. 30 seconds. We'll get started. We're going to correct Lecture 8, and then we're on to the rest of the Bill of Rights. Good deal. Bianca, good to see ya. I got to keep this unbuttoned. I have a little surprise for you guys tonight. Oops. All right, it's 8 p.m. I did not see the woman on the house floor. Any audio? Are you guys picking up audio? Does everybody get the audio? I hate to say this, Tracy, but it might be on my end. It could be potentially on your end if the volume's not cranked. I'm not sure. Let me know. Has everybody got audio? Looks like Chris said he's got audio. I'm going to pray here. If that audio thing doesn't clear up, Tracy, maybe I need to start and restart again. Let me know. Lord, we thank you for this night. And I just thank you for this opportunity again to study our liberties, Lord. As we walk in them, Father, we thank you for your grace. We thank you for your power. And I thank you for your right hand and for that blood of your precious Son, Jesus Christ, that was shed for us on our behalf, Lord. That mankind was redeemed unto our Savior, in whom we study. And may we discover new things of you tonight in Jesus' name. May you reveal your mysteries unto us as we cover these amendments, Lord. And Father, may we partake of the revelation which was given to our founders. Amen. Perfect. Great. We got Tracy. We got everybody. Can you send me a link of that, Chris? I'd sure like to see the woman on the house floor. I've been buried literally for the past couple weeks, so I've been just focusing on what my tasks are at hand. But I'd like for each of us to turn to our Lecture 8 test, which should be on page 189, I believe, in your syllabus. And we'll get started. James Madison believed that no Bill of Rights was necessary because, D, he saw no need to prohibit government from doing what it had no authority to do in the first place. That's good in theory. Number 2, the lack of the Bill of Rights in the original Constitution. B, was a principal objection of the Anti-Federalists. Number 3, Madison's 12th Amendment, which dealt with congressional pay raises. C, was finally ratified in 1993 as the 27th Amendment. Number 4, each of the first 10 amendments. A, limits federal power. Number 5, originally the Bill of Rights limited only the B, federal government. Didn't touch the states. As a matter of fact, it had nothing to do with them. Sorry, just had to grab my water there. Number 6, religious liberty is a D, biblical concept. God is the author of our religion, therefore that concept belongs to him. Number 7, Jefferson's wall of separation was meant to describe B, the protection of the church from the state. Number 8, Jefferson's words are now quoted by the court. D, out of context, completely out of context. Number 9, the Supreme Court tests in Lemon versus Kurtzman says that for a law to be constitutional, D, all of the above, it must have a secular purpose, it must not constitute excessive entanglement of government with religion, its primary effect must not be to advance or inhibit religion. Number 10, the following is not protected by the First Amendment freedom of speech clause. That is D, all of the above. Fighting words are not protected. Obscenity is not protected. And C, defamation is not protected by the First Amendment. Moving on now. If at any time you all have a question on the test, just stop me or send me a message or shoot me an email. Lecture 8, true and false. Number 1, God was acknowledged as a source of civil government authority in most colonial charters. That's true. We covered those last week. All law is based, number 2, on moral values, which have their roots in religion. That's true. Number 3, the view of the framers concerning the Establishment Clause was that no denomination be given official status or preferential treatment over others. That is also true. Number 3 is true. Number 4, with respect to the Free Exercise Clause, the word exercise refers only to conscience. That's false. Remember, exercise gives you the ability to exercise. Number 5, for 170 years, the word church in Jefferson's phrase, separation of church and state, was taken to mean a federally established denomination. Number 6, the right to assemble grew partly from the king's insensitivity. Boy, I hope it's not cutting in and out. I've got a strong connection here. Please let me know if that continues, Chris. Because if it does, I'm not sure. We got to do something else to make up for that. Number 6, the right to assemble grew partly from the king's insensitivity to the colonist grievances. That is true. Number 7, Justice Joseph Story wrote that Christianity should receive no encouragement from the state. That's false. Number 8, Hamilton thought that a Bill of Rights would be dangerous because a strong central government was more important than individual liberties. That is false. That's not the premise why he said it. We're going to discuss why he said it in this lecture as well. Number 9, the Magna Carta is an example of Englishmen asserting their ancient rights. That is true. We've always had God-given rights. Sometimes we have to reassert them. Number 10, actually we always have to reassert them. Number 10, the Ninth Amendment may be seen as Madison's answer to Hamilton's concern. That is true. Let's cover this now. That was kind of a premature question on that last one, the Ninth Amendment. Is everybody seeing me clear? It's not breaking out anymore. I'll give you a second to react to that while we all turn in our lecture books to Lecture 9, and we're going to cover the amendments, the Second Amendment through the 10th Amendment. The answer to number 5. Let me just go there. I have to read it again. Thank you, Bianca. And anybody else, if you ever have questions on what answers were. 5 on true and false is true. 5 on the main question and answers is C in the multiple choice. C, wait a minute. I'm so sorry. That was lecture 7. Let me get there again. Sorry, I gave you the answers from lecture 7. Number 5 is true on lecture 8, and number 5 in the question and answers is B. So B and true. B and true. Be true. Got everybody here. Good. Looks like everybody's good on the webcast now. Perfect. We'll move forward. Thomas Jefferson said that God who gave us life gave us liberty at the same time. Right when they happen, they attach to our physical being. Can the liberties of a nation be thought secure when we have removed the only firm basis, a conviction in the minds of the people that these liberties are the gift of God? That they are not to be violated, but with His wrath. That's what we can expect and anticipate when a nation disobeys God. We can expect His wrath. That's a promise. That's far more promising than anything Congress writes, says, agrees upon, or delegates down. God's promises are sure and fixed to the righteous and to the unrighteous. from the preamble of the Bill of Rights. There was a preamble. I encourage you to read the Bill of Rights, read the preamble. The convention of a number of states having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its power, speaking of the Constitution, that further declaratory and restrictive clauses should be added. Remember, this limited the federal government. And as extending the ground of public confidence in the government will best ensure the beneficent ends of its institutions. So in other words, they said, hey, look, in order to make the Constitution even more perfect, when I say perfect, I'm saying that tongue-in-cheek. I don't mean it is perfect. But to make it even better, we're going to add a Bill of Rights. Now, I don't read through the general objectives or the specific objectives. When you're done with the class, please read through those yourself and say, hey, did I learn these things? The Bill of Rights, last week we covered Article 1. That was a long one because it engages 5 important liberties that are protected by the federal government, acknowledged and protected by the federal government through Article 1 of the Bill of Rights. It's the one that's being most construed. It's the one that deals closest with religion, which is the most important liberty that a nation can have, because all of our rights, all of our moral understandings and laws and precepts are all religious. So that is the most important. Now we're going to continue on. The Bill of Rights, if the Constitution with its 7 articles is like a football field, we've given this before, we've chalked out the lines, it's a football field. The sidelines and the end zone define the field of play. When the ball, it's a big old rectangle, when the ball goes out of bounds, the play stops. After we bring the ball back into play, when we bring it back into play ball. That's what time it is. I'm sorry, guys. The limits of powers and the exercise of those powers are clearly defined in the 7 articles of the Constitution, which we've described again. However, the problem is those boundaries on a football field consist only of some white chalk lines. So what's going to prevent a player from running over the side of them? Now, if the people who are the referees will stop the play, blow the whistle, and give no credit or lip service to the players going outside of the bounds, then we're cool. But if not, then what's going to stop them from going outside of bounds? The Bill of Rights. Because many people, especially the Anti-Federalists, feared that there wasn't enough authority or power to keep the federal government within those bounds. So we came up with the Bill of Rights. The Bill of Rights erected a thick brick wall on the sidelines and the end zone to go beyond merely defining the field of play, but moreover to prohibit the ball from ever even getting there. So that was going to say, listen, no chalk lines, brick wall, you're only going to hit it, and you're not going to win, because those are our rights as they're clearly defined. The Second Amendment says, a well-regulated militia being necessary to the security of a free state. Now, I want to share this with you because this is part of my outfit tonight. And I hope you all enjoy this, but you will notice that I got this shirt. It's actually from my father. He bought it for my birthday a while back, but you can see right here that what my shirt says. It says first of all, I proudly support the Second Amendment, the right to bear arms. You like that? My bare arms? So, for any of you who want to support the right to bear arms, I am in a state called Maryland right now. The Institute on the Constitution, the American View, we provided a course this past Saturday for you to get your permit to carry. This is in 26 states. It's the Utah permit. It was given here in Maryland, which is where we're headquartered, right just outside of Baltimore. But it did not include Maryland because Maryland does not offer that to its citizens. Well, we could say, so what if Maryland does? So what if it doesn't? The bottom line is we are guaranteed the right to bear arms by the Constitution. And if the Constitution is the law of the land, it then trumps that state law. So that is the concept. And I want everybody to follow that with me for a second. But some people, I don't... The right of the people, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I don't get how that's confusing, It's not confusing. It's pretty straightforward. Now, in your homework tonight, I'm going to send you something. It's an article that's in the Blaze, that was in the Blaze. The incorrect description of the right to keep and bear arms in a state militia makes one's rights dependent upon one's membership in a state militia. Listen to the quote in this textbook. It's a high school textbook. This was taken in Denton, Texas. It says this. Oh, where are we going? Here we go. I'm so sorry. I'm trying to read where it is. The right to keep and bear arms in the state militia. Come on, you stupid thing. Where is it at? The founders believe it. Okay, I'm so sorry. But basically what they said, you have the right to keep and bear arms in a state militia. The right of people to keep and bear arms within a state militia. That was how it was listed. Why was it listed that way? Because it was saying the only time you have the right to bear arms is while you're in the service of a state militia. Now, to listen to that, many people would say, well, that makes no sense at all, which it doesn't. Again, a well-regulated militia being necessary to the security of a free state. Okay? The right of the people to keep and bear arms in the militia shall not be infringed. Okay, yes, there is people in a militia. That would make sense that the militia has the right to keep and bear arms. Otherwise, how in the world would it even be a militia? This is so misconstrued and stupid. But again, we're teaching kids that don't even know the difference. And if their parents are brain dead on this topic, they're not going to be able to instruct them differently. Half the time, parents don't even talk to the kids about what they learn. The kids may think, oh, yeah, okay, so we have the right to bear arms if we're part of the militia. Okay, well, that makes sense. Yeah, okay, the militia needs guns, so you can have guns if you're in the militia. But you can't if you're not. They don't have the right to amend that. Thank you, Chris. Of course they don't. This is merely a manual. The school district says it only uses the book as supplemental, and in disseminating the correct information on the Second Amendment from other texts. So they say that they do more readily explain it. I'm just glad for the pressure that was put upon that school district, but there are several other schools that appear to be using this same book too. Now, what is it? Is it conspiratorial? Is this on purpose? Is this what the school district is trying to do to dismantle in the minds of our students this Second Amendment? I want to take you through a freaky area here, okay? Because I had no idea how in the world anybody, these brain-dead politicians who stand up and try to bring on gun control, okay, gun control, how in the world they can circumnavigate the Second Amendment. They've been doing it for years, by the way. But how is it even possible? This is so plain and obvious. The right of the people to keep and bear arms shall not be infringed. The right of the people. Now, remember, we have rights, but when we break the law, we forfeit certain rights. So if you're a criminal, if you're a felon, etc., you no longer have that right. That's what we've decided collectively as a nation. Let me move on. There's two views. Now, the collectivist view is this. This is important to understand. The collectivist view. This is where all of us together have the right to keep and bear arms. This gets a little freaky, and it gets far out there. And frankly, I'd never heard of it until I studied this course because I didn't understand how people could even propose certain gun control measures and just completely completely disregard the Second Amendment. What they say is the people collectively bear arms by maintaining a national guard or police force. So, the people can agree together to arm certain people. That's what they're saying the Second Amendment means. Doesn't mean that you and I have the authority or the position to be able to do it. We agree together to delegate to our police force, to our National Guard, to whomever it is, to keep and bear arms. Yeah, I meant that. Now here's the other view. These are for normal, sane thinking people that are not criminals trying to tyrannize the people. The real view of the Second Amendment protects the individual's rights. The right of the people, that be us. Not the right of the police force, the right of the militia, as that school textbook said. And I'll send you this again on homework. You'll have the link to this. It's unbelievable. In Denton, Texas, where they literally had this written. The right of the people in the state militia to keep and bear arms shall not be infringed. Now, it's ridiculous. The people had arms before they joined the state militia. Think about this, though. Think about this new mentality, okay? Because a lot of people have swallowed this pill. most people are just ignoramuses. They never study it forward. And this is a political agenda purely, and they're prejudiced. And so they try to leverage and utilize whatever they can, because most of these people are attorneys. They try to screw around with the words and try to sell us a bill of goods here. In this particular setting, let's just say that it's collectivist. We have a Second Amendment right collectively. Do we have a First Amendment right collectively? In other words, the freedom of the press can only exist so long as the people delegate the press through the state? Well, no, then there would be no check on the state. If the state was the press, there would be no freedom of press. Therefore, it has to be in individuals. Don't buy into this collectivist view baloney. It's an individual liberty. Now, I'm talking to sane people here, so I realize that this thought and this argument hasn't even entered into your mind. But no, this is where some of these people have been brainwashed. Some. Most of them have just taken with the Pelosi's of the world. Remember last week we talked about Miss Pelosi? Oh yeah, we believe in a Second Amendment right, the freedom of speech. No, excuse me. We believe in a First Amendment right, the right to bear arms, whatever. You've heard the windbag talk before. The meaning of militia is not just a National Guard or a police force. I'm going to drill down a little bit more on this. This one's very important. And frankly, it sets the stage for a lot of other of individual liberties that are being attacked right now, being attacked by the very ones that are secure them and preserve them. This particular view, by the way, this collectivist view, never even popped its head up until the end of the 1800s. That's right, the Communist Manifesto. We can see a lot of the things. If you read the Communist Manifesto and you read the planks, thank you very much, Chris. Very good feedback there. Input. The Communist Manifesto, you read the planks. We're going to get actually to the end of this, but we've discussed these at length in other lectures. If you read them, you can see that the Democratic Party, along with the capitulating Conservative Party, that is the pathway that we've been taking for some time. The end of the 1800s, we got in this collectivist view. Communist Manifesto, as Chris just pointed out. And in the early 1800s, we had the same thing. So here, at this particular point, we never even discussed it in the 1700s, wasn't on the books, wasn't on the record. This retarded theory didn't even exist till the end of the 1800s. We talked about Jefferson's letter. 150 years later, it's being quoted. So what they're doing is pulling arguments. No, they're not pulling arguments, excuse me. They come up, it's a posturing. They've come up with their own viewpoint, and they're trying to find supportive evidence. They can't find that, so they twist, bend, and distort. They utilize words, change the meanings of those words, and then sell their argument. Think about this, though. You can't have a collectivist view of the First Amendment, the Fourth Amendment. I mean, imagine the right to privacy, personal property, Fourth Amendment. Do we only have that if we're all together? Does that mean our group, our church has the right to private property, but us as individuals, we don't? Privacy? I mean, as long as we're together in a big crowd, we can't get frisked, just being stopped and frisked. But if we're not in a big crowd, individual property, privacy, sorry, bud, doesn't exist. So you got to travel in a crowd all the time. It's just stupid. Doesn't even make sense. If this is another thing we need to understand too with our rights, when we delegated powers is what we've given to the federal government. In other words, the power starts with whom? Us. We have a power. First Amendment, Second Amendment. Let's talk about the Second Amendment. We have a Second Amendment, which means government shall protect our right to keep and bear arms. Police officers carry guns, militia, army, etc. Where do they get the right to keep and bear arms? Well, they represent us, so we give them the power to do so. They don't have a God-given right to do that. We have the God-given right. Therefore, we take our right, we delegate it to the government entity. Now, when we do that, do we then lose our right to it? Well, I'm giving up my right to keep and bear arms to the federal government. That'd be stupid. You're like a bodyguard. You hire a bodyguard, and the bodyguard is there to protect you. You pay him, and you delegate certain authority to him to protect and preserve your life. So you go out on the street corner, and some thugs approach you and ask you for your wallet. You say no, and your bodyguard decides, you know what, I'm not on the clock right now. I'm going to go have a burger. I'm going to take a nap. I'm not really concerned about Mr. Jake. Besides, he's got big pipes, right? Do I forfeit my right because I've delegated the right of him to protect me? Do I forfeit it when he's gone? How? So because I've delegated a right, or I've delegated an authority to a police force to carry a gun, does that police force have the right to use the authority I delegated to it, to use it against me? And if I do delegate that authority to that police force, do then I give it up myself? No, no, no. None of the above. If the police force is not available to protect and preserve my rights, do I have the ability to protect and preserve my rights using arms? Yes. 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 I hope I've exacerbated that enough, but I'm going to keep going on this because it's important. Very important. All the other rights become meaningless unless we can by force protect and preserve those rights. Noah Webster said in 1828, the militia of a country are the able-bodied men organized in companies, regiments, and brigades, with officers of all grades and required by law to attend military exercises on certain days only, but at other times left to pursue their usual occupation. These people weren't to be full-time militiamen. They were to be there if they were called on, and this is all able-bodied men. All able-bodied men. English law, at least from the reign of Alfred the Great, this was in AD 871 to 899, required all able-bodied men, there's that term again, able-bodied men, according to English law, common law, to purchase weapons and be available for military duty. In other words, you had to own a weapon. It wasn't an issue of you have the right to have one or not. You had to own one. You had to purchase one. That was a mandate. Same thing as in Kennesaw, Georgia. They mandate that people own a weapon. Now, they don't prosecute anybody that doesn't, but that's a very safe community. As a matter of fact, prisoners taken from a county next to them said, no, you don't ever go in there and do your crime. It doesn't mean that crime doesn't exist, but it's at a minimal. Crime prevention is people being armed to protect themselves against criminals, because the police officers can't be everywhere at every time. They're not omniscient like God is. But it's a prime example of the police officers being delegated certain authorities for larger criminals, perhaps, but as an individual, mano a mano, I can still protect my rights. If the Second Amendment protects only collective rights, the state to maintain a police force, it's out of place in the Bill of Rights, which protects your individual rights. We talked about that. Framers saw individual ownership of firearms as a protection of freedom against both foreign invasion, of course, protect ourselves while we have armies. We need weapons to fight off foreign invaders, but also domestic tyranny. Listen to this. George Washington said firearms stand next in importance to the Constitution itself. They are the American people's liberty teeth and keystone under independence. You drop that keystone, your independence falls. To secure peace, security, and happiness, the rifle and the pistol are equally indispensable. The very atmosphere of firearms everywhere restrains evil interference. They deserve a place of honor with all that is good. Samuel Adams. Think about that. Think about that. Samuel Adams said the Constitution shall never be construed. Never. It's the son of liberty. To prevent the people of the United States who are peaceable citizens from keeping their own arms. Doesn't get any plainer than that. Right out of the founder's mouth. This is not going to ever encroach upon our right to own arms. Thomas Jefferson, no free man shall ever be debarred from the use of arms. You know why? Because the minute a man is debarred from the use of arms, he is no longer free. Noah Webster said, before a standing army or a tyrannical government can rule, the people must be disarmed, as they are in almost every kingdom in Europe. Speaking of that, back then. The supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any band of regular or professional troops. See, us together, we way outnumber. If you consider the people, the people that own firearms in the state of Michigan, so far outnumber all of our military. It's an astounding statistic. It's got to be. Just Google it once, and I really should have had that tonight, but it just sprung on me. I can't recall what it is. But it's amazing how many more American citizens are armed than they have of the DHS or anything else like that. So an unjust law can never be forced upon us. A 20-year history of the right to carry laws across America. The principal agency and nature of the power to bear arms by sheriff and police. Now, these are things that we have here at the Institute on the Constitution where you can actually take these DVDs and things like that. We have a lot of them on the store, so I encourage you, theamericanview.com. There's a store there where you can get more information on the Second Amendment. There's a lot deeper expose on this, but I'm merely scratching the surface for the point that we get the meaning, the true meaning of the Second Amendment. Let's move on to the Third Amendment. Now, this is about quartering troops. Quartering troops was a British practice of forcing private citizens to house soldiers. And the reason that they housed soldiers was because, first of all, it was free. Second of all, those soldiers could come in. They could have quarter. They could have food. They could have, well, there you go, quarter and food. Plus, there was this theory and concept that we are greater. So psychologically, it was telling the colonists that I'm your daddy. But I want you to understand this too, because more than this, I had not even known this until I started teaching this course. Number one, the Third Amendment says that we prohibit that unless the owner gives consent, or it's wartime. But even then, it's in a manner prescribed by law. There has to be certain parameters as to how troops are quartered. The experience of the War for Independence shaped this amendment. I'm just going to read this, the Third Amendment. No soldier shall, in time of peace, be quartered in any house, in time of peace, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So if in a time of war, there's parameters set. This is a letter from George Washington. It's in your student book. And it covers a topic that's very disturbing, but I want you to know that this was happening then. So it wasn't just an issue of, well, we didn't like the way that the British troops smelt. They ate too much of our food. They took over my bed. They took over the wives, too. Robert Combs, a tavern keeper. This is a letter written from George Washington to William Livingston, who's also a signer. He's the governor of New Jersey at the time. Robert Combs, a tavern keeper in Pennington, can inform you of a rape committed on the wife and daughter of one John Christopher by the enemy while they lay there. One Philip Palmer's daughter of that neighborhood was also ravished by 6 soldiers. Thomas Keene's daughter was treated in the same manner. Those facts I did not particularly recollect, and he finishes it on, but he wanted at the time of writing to you on the subject of the enemy's brutality. So he's speaking of these things that were going on. So when they when they created this amendment, it was for this purpose. This is what they'd experienced. A long train of abuses, says the Declaration of Independence. Well, this was after that. They were still abusing. Why? Because they did not fear God, and any government system that does not fear God, this is what's going to happen. The Fourth Amendment, unreasonable searches and seizures. So we'll read that amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And this is great. I want to go into this. The background is the law of nature, and nature is God. The Bible for this amendment. A man's house is his castle. Matthew Henry wrote a commentary on Exodus 22. And this is what he said, quote unquote. It's right in your notebook here. A man's house is his castle, and God's law, as well as man's, sets a guard upon it. He that assaults it does so at his own peril. In other words, there's no justification to do it. You may die if you try to do it. In Book 4, Chapter 16 of William Blackstone's Commentaries on the Laws of England, and the law of England has so particular and tender a regard to the immunity of a man's house that it styles it his castle, and will never suffer it to be violated with immunity. In other words, you can't just go in and do what you want to do. For this reason, no doors can, in general, be broken open to execute any civil process, though, in criminal causes, as for the criminal being hidden, the public safety supersedes the private in criminal causes or cases. Hence also, in part, arises I don't know what that term exactly means. Animadversion. Omit a diversion. I think it's just a spelling error in there, I hope. Or maybe that really is a word, forgive me. Of the law upon eavesdroppers, nuancers, incendiaries, and to this principle it must be assigned, that a man may assemble people together lawfully without the danger of raising, rout, or unlawful assembly, in order to protect and defend his house, which he is not permitted to do in any other case. So what do we have here again? This is just another example. This is another example of the fact that I'm just trying to follow you guys on Facebook so I don't miss anything. That our rights of the Fourth Amendment, our house is our castle. This protects against invasions of privacy. The key word is unreasonable. Now notice, no unreasonable searches or seizures. This has to be unreasonable. If it's reasonable, what defines reasonable? It does not protect against all searches and seizures, only those that are unreasonable. So how do we define that? Let's go. In order to be reasonable, if you turn your page to 198, it has to be accompanied by a warrant. What's a warrant? How does a police officer get a warrant? It must be supported by probable cause. So there must be a cause. It can't just be, I got a feeling about this guy. I want to go search his house. It has to be probable cause. Hey, a witness has told me and can affirm that such and such has this in their house. It must have probable cause set forth in an affidavit, so that must be written. And it must be authorized by a neutral and detached magistrate. In other words, a judge has to give authority. So there's all these checks, all these steps to go through before an officer can break into one's home. In extingent or urgent circumstances, the requirement of a warrant does not apply. This is a search incident to lawful arrest. So in other words, a criminal is out committing a crime. I don't need his permission then to search him. If a man is drunk, as an example, I don't need his permission to search, or if he's under the influence of a drug or something of that nature. Or hot pursuit of a fleeing felon. If a felon is fleeing in high-speed chase through an area and he's going 90 and a 40, listen, he's broke the law. Now the next step is to pursue him and be able to search his person's papers or effects. Or a bona fide emergency. Now this is the biggest one that has been used to delineate our personal privacy and our personal rights. Lesser invasions of privacy, like a stop and frisk, can be justified with less than probable cause. This applies whenever there is a reasonable expectation of privacy, not to items in plain view. If somebody is driving down the road and he gets pulled over and he has drug paraphernalia sitting on the dash of his car, the police officer at that moment now has the right to search his car. You can't say, hey dude, man, I've got a right to personal property. You can't do that, man. Or if he's got drugs in his ear, he's got a joints in his ear, or, I think Colorado now is a state. I think a couple other states may legalize the growth of marijuana. But if you got a marijuana plant growing in your front yard, you kind of blew your cover there, and it's in plain sight, so you forfeit your right, your Fourth Amendment right. Exclusionary rule. Now, this is important to understand. The courts have created this exception, but an exclusionary rule is evidence seized in violation of the Fourth Amendment. So say a police officer breaks into a guy's house without a warrant, and he finds crime paraphernalia or what have you, and then they indict the man and he's found guilty. But then a judge says, wait a second, by what evidence? The evidence shared was in violation of the Fourth Amendment, therefore that evidence gets thrown out. That criminal could go free, even though there's evidence there because it was obtained improperly. This is basically exclusionary rule. It's not specified. The courts have adopted this rule because they thought it necessary to make sure police respect the Fourth Amendment. So this is a check upon the police officers. Fourth Amendment. The Fourth Amendment limits government's authority to invade individual citizens' person or property without a good cause. What about the Patriot Act and its reauthorization? Now, the Patriot Act was given to us what? In an emergency. Remember, a bona fide emergency? Opponents of this particular law Opponents of this particular law have criticized its authorization of indefinite detentions of immigrants, searches through which law enforcement officers search a home or business without the owner's or the occupant's permission or knowledge, the expanded use of NS national security letters, which allows the FBI to search telephone, email, financial records without a court order, and expanded access of law enforcement agencies to business records, including library and financial records. Now, since its passage, just an FYI, and this is a good thing, and this is what you hear all the time. We always hear about the bad cases that courts and things like that give to us. But we don't want to sensationalize that because it's by far not happening nearly as much as judges are striking down unconstitutional laws and violations. Since its passage, several legal challenges have been brought against this act, and federal courts have ruled that a number of provisions are unconstitutional. Now, the Fourth Amendment, I want to just cap on a couple other things. Many people say, well, and this was brought along, of course, after the 9/11 attacks in the airport. Listen, you can't, there has to be probable cause, in other words, or a crime has to have been committed in order for you to forfeit your Fourth Amendment right. Now, when you go to the airport, no crime has been committed, yet you're searched. You're fully searched. I hate it every time I go into that airport. I purposely wear jeans and try to wear jeans. Sometimes I forget where there's no zippers on it because I have a serious problem. As a matter of fact, I can't even help myself when I go through there. And they start getting stupid. They want to touch me. They want to frisk me and stuff like that. I've actually taken issue with a couple people. I wasn't sure if I was going to be able to make the flight at that time. But thank God somebody with a head on their shoulders, well, semi-head, from the TSA came in and said, "We're sorry, sir. Can I just explain to you this is all I need to do, blah, 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 blah." Because you got old stinking doofus over there who's on a power trip thinking he's just going to tell me, I'm gonna frisk you. No, you're not. Here's my pocket. There's a zipper here. I'll let you feel that zipper. Things like that. But anyhow, no crime has been committed. But the way that they try to tie you into this is when you buy your ticket, you agree to be searched. You forfeit your right when you buy that ticket by contract. Now, that could be under duress, that could be under coercion. We can consider that. But the fact is we can take this to that particular, our Fourth Amendment right is being violated when we go to the airport. Well, then you could say, well, you don't have to fly. Well, there's only one way for me to get from this point to that point in the timely manner that I need to get to it. So there's the coercion factor. I told you about if items are in plain view, there's no expectation of privacy. If you got a brick of cocaine sitting on your dashboard, you can't expect your privacy to be respected by a law enforcement agency. You forfeited that right. The Fifth Amendment. This is personal and property rights. Now, I would read the Fifth Amendment to you, but it's very long. So I want you to do it. I want you to do this. I want you to read all of the amendments, as a matter of fact. But we're going to talk about this. This is about a grand jury indictment as a portion of it. And this is for a capital or otherwise infamous crime. Now, why is that? Why is the grand jury brought up? By the way, a grand jury is of 23 people. 23 people, that's very significant to the Bible. It's also the Sanhedrin. The Sanhedrin were the ones that were in charge of judging the law. So here you have a grand jury. The grand jury is a buffer between the citizen and the state. When the state wants to come down and prosecute a citizen, said, wait a second, we're going to put a jury right in between you. You cannot be convicted or go to trial until you're indicted by a grand jury. By the way, Trayvon Martin was not indicted by a grand jury. This means no one should go through the expense, trauma, and jeopardy of a trial unless a grand jury or common citizens determines there is probable cause. As a fact-finding body, the jury also acts as a check on government. They say, hold on, bud, you can do nothing until we'll determine. We're the citizens, we're the grand jury. Military cases are accepted. The Fifth Amendment expressly recognizes capital punishment as well. No person shall be deprived of life, liberty, or property without due process of law, signifying that if there is a due process of law, a man is found guilty, he can be deprived of his life, liberty, or property. That's right there. Now, it's contrary to what many people have twisted and construed the Eighth Amendment to mean, but we'll get to that soon. A cruel and unusual punishment, that is. We literally have capital punishment in this amendment, the Fifth Amendment. Double jeopardy. A person cannot be tried by the same jurisdiction for the same offense. Otherwise, what they do is they just keep on trying until they get the verdict they want. So if the state says, well, he was found not guilty. Well, let's just get a new jury in here and let's try him again. Oh, he's found not guilty. Let's get a new jury and try him again. You can't do that. You can't do it twice. This was designed to prevent government harassment, essentially, is what it would create. No compulsory self-incrimination. In other words, a person can't be coerced. A coerced confession may be false. Maybe they threaten, maybe they torture, maybe they do certain things where they're coercing that confession. So a man can't be coerced because he may just say, okay, stop it, I'll tell you anything that I want. Coerced confessions violate human dignity by forcing a person to cooperate in his own self-destruction. Can't do it by force. Now, a man can admit to his guilt, but he can't be coerced. You have to have witnesses for that. Courts have recently ruled that custodial interrogation is inherently coercive. Therefore, police must read Miranda rights to a suspect to ensure any waiver of his Fifth Amendment rights is truly voluntary and intelligent. You have the right to remain silent. Anything you say can or may be used against you in a court of law, etc. Telling that criminal, you don't have to say anything to us. You have the right to an attorney. You have a right to a trial. Okay, where we can discuss those things. But if the police are kind of banging up on him, twisting his arm hard, slamming him into the ground, saying, you're guilty, admit it. Well, he can be released on those very grounds. Courts cannot be deprived of life, liberty, or property without due process of law. Due process means procedures essential to fundamental fairness. So this would be a proper trial. You cannot take private property for public use without just compensation. Now, I wish it would have stopped without those last three words. Cannot take private property for public use. But it says without just compensation. What does that mean? That's signifying eminent domain. Eminent domain. What is taking? What is taking? It's something, but again, eminent domain is something that's taught. Most people, when the state or the government wants to take their property, they offer a price. Of course, the person may take that price. Maybe he'll love that price. Maybe he won't. But that's up to the person. It's his property to determine that. But you see a lot of eminent domain cases where these people are having the property taken from them for not a fair price, according to the people. But it does put that in the Fifth Amendment that your property may be taken from you with compensation, of course. It can't be taken without compensation. But if the government doesn't take the title to your property, let's just say that it doesn't. What does taking mean? Perhaps they limit your use for that property. Maybe they could say that, sure, we know that you own that, but that's not zoned correctly for a building or conducting business on it. Well, then what good is the property for you if you're a business owner? They might as well take it from you. So there's other ways to get around this where people can get manipulative and things like that. That's why it's so important for the citizenry to be involved in their local government and not allow encroachments from bigger government to come in. We go on to the Sixth Amendment, the right of criminal defendants. Again, Sixth Amendment is fairly long. I encourage you to read it. But this is what are the rights of a criminal defendant, somebody who has not been convicted yet. He gets a speedy trial. What is speedy depends on all circumstances, of course, where the crime is committed, the witnesses, etc., how long it's going to take to bring the jury, how, etc., the evidence, the in-depthness of the crime. A public trial. Public trial is less likely to be arbitrary and unfair if press and public are present. So you get this so that it's not just a closed door and all the evidence is in, you're in and out, and nobody knows what happens. And next thing you know, you're in jail, and nobody knew what happened. So this keeps it public for people to be able to watch this and keep a check. Jury of state and district. You can see Lecture 7 for that. We talked about that. Be informed of charges with sufficient particularity and sufficiency in advance to prepare a defense. So we need to understand what we are being accused of for a criminal defendant so that we can prepare our defense. We may get locked up and not even know why. This prevents that. Confront and cross-examine your accuser. So if your accuser comes on the stand, you get the opportunity to cross-examine them. Subpoena by force. Subpoena is force. Witnesses to testify for your defense. So say somebody says, no, I don't want to get involved in it, and they were a key witness to your innocence. You can force them to witness, come up to the stand. Assistance of counsel is the right to qualified attorney at the state's expense if the defendant cannot afford one. Of course, you have that public defenders. The Seventh Amendment, the right of civil cases. This is the right to a jury trial in cases involving common law and more than $20. It's still in the federal Constitution, but that value obviously has changed significantly. A judge cannot substitute his opinion for that of the jury unless he determines that the case was erroneously submitted to the jury or that no reasonable jurors could have reached that verdict. In other words, if it's so blatantly prejudiced. Now, a judge is not going to want to overrule a jury except for in very specific cases. So this is a good check. Again, not only on the jury, but also on the judge, too. Again, we're talking about people. There's always a delicate line. You can go left or right with this thing. We want to stay in the center, so this was providing for that. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment afflicted. Now, a defendant is presumed innocent, therefore his right is to be free until conviction unless he poses a danger to public safety or is likely to flee. This is excessive bail. In other words, you can't say to a guy who's being accused of a small crime that your bail is $6 million. So the bail is determined, the purpose of the bail is to make sure the defendant does not flee before trial, pending trial. So what they say is, we will let you out on bail, but we're going to put enough of your skin in this game that we know you're going to come back to the trial. Bail should be no more than necessary to ensure defendant's appearance. No more than that. No excessive bail. It's not necessary. That amount depends on all circumstances, the nature of the offense, the defendant's record, defendant's ties to the community, so we can kind of see, hey, this is the first time, it's a small offense, we'll set the bail low. This is a guy who is not tied to this community, he's an outsider, this is his third offense, he's a felon, and blah, 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 so you can kind of determine where the bail should be. The purpose of the bail is to keep somebody there until the trial's over, because he is free. He's innocent until convicted. No excessive fines. Excessive is that which is unreasonable considering the nature of the offense. So if a man is charged and accused of shoplifting, as an example, he's not fined $10 million or what have you. The Bible does say you restore fourfold, so perhaps that's a standard. I know that those benchmarks have been now determined by judges. Magna Carta describes excessive fines as a forfeitures that deprive the defendants of his ability to earn a living. So if he does get fined, it can't be fined so intensely or in depth that he can no longer make a living. There's no cruel and unusual punishment. This is the important one because this is where the death penalty has been axed from many states because of what the Supreme Court Justice Brennan and Marshall, Thurgood Marshall. The framers wanted to prohibit unusual torture, disemboweling, and mutilation. This had happened. It happened through the Dark Ages and then carried on into even the time of some of the founders where these things were done. They wanted to prohibit torture. Waterboarding, we could call it nowadays. But that's why they put this. No cruel and unusual punishment. Okay, they did not negate the death penalty. Remember, a person could be deprived of life after due process of law. Framers would not have considered capital punishment cruel and unusual. It's impossible. They wouldn't have put in the Fifth Amendment then. Justice Brennan and Marshall have argued that the Eighth Amendment must be interpreted according to an, quote, it's in your book, evolving standard of decency. Seems to me in our society in this day and age, when the Supreme Court, and all branches of government for that matter, have agreed and in concert for the butchering of small children inside of a mother's womb, I don't think we're evolving in decency. Yet we will protect a man's life who has taken another man or woman's life, or who has raped a woman. Or in this day and age, a man who has raped a little boy. Cruel and unusual punishment? We've got the roles backwards. And these clowns said that it must be interpreted according to an evolving standard of decency. We know those dead old white guys, those lunatic rebels who they believed in capital punishment. We don't. We're evolving decently. Society has evolved to that point. The capital punishment is cruel and unusual today. This isn't the case. Furman versus Georgia. In 1972. A year later, the Supreme Court comes up with another. Remember, they're evolving to decency. Comes up in 73. says it's okay for a woman to go into a doctor and have her baby ripped to shreds because we're evolving in a more decent society. Who can say, you look historically speaking, when a nation indulges in sin, in many ways we have evolved in the right areas. There's no doubt about it. According to Christian precept, we've evolved there. How many societies? It's never proven that way. Society can evolve good or bad, but law cannot evolve. The standard of right and wrong and morality cannot evolve. That's God's fixed standard. That's the only protection, safety of our rights. The Ninth Amendment, I don't know, that's just something that we all need to consider even deeper, where our priorities have flipped. And see, that's the difference. Listen, you and I can walk in an authority that will not be challenged, and if it is challenged, we win, so long as we walk in truth, we walk in uprightness. You know, there's certain people that I've been around in the past, ever since I've grown up, their communication that comes out of their mouth, they see no problem with swearing, they see no problem with watching movies that are compromised or have compromised things in them. I don't want those things in my life because I want God's witness to the truth that's in operation in my life. That's what I want. That's all I care about. And if we as a society care about that, we're going to walk in that authority. And it doesn't matter what a judge says. That's why it's so important for us to understand the truth, but then walk in the truth. The Ninth Amendment, unspecified rights. Okay, because remember, Hamilton said, well, how in the world we're going to create a Bill of Rights, but we could never list all of our rights. And if we forget to list some of them, the government might come in and say that we don't have those rights. Well, listen to this. The enumeration in the Constitution of certain rights shall not be construed. So in other words, there's certain rights here, but it shall not construe to deny or disparage others retained by the people. So just because it's not in here, and if it's not in here, it belongs to us. Hamilton had objected, like I said. The key word is retained. The Ninth Amendment does not give courts the authority to create new rights. Rather, the Ninth Amendment protects only those rights which were already recognized and protected under the then existing English and American common law. There's our biblical law right there, common law. Now, the 10th Amendment, a lot of the Tea Parties have kind of reinvigorated our culture with this, and thank God that they have. This is very important. The 10th Amendment says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states. It's been prohibited by the states. This is the old adage, or the people in government now say, well, it doesn't say we can't do this, therefore we can do it. No, 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 no. The power is not delegated to you, nor prohibited to the states, are reserved to the states, respectively, unless it's prohibited in the Constitution, or to the people. So if it's a right not delegated, it's prohibited from the state, it belongs to me and you. If it's a right not delegated to the Constitution, and it's not prohibited to the state, it belongs to the state. See, here's the confines, here's the lines. All these lines exist. There's borders and boundaries. It's our job to be a check to make sure that those borders and boundaries are obeyed. How can we do that without a Second Amendment? It's the cornerstone of freedom. It sets in concrete the framers' view of the covenantal nature of government. In other words, the people were given God-given rights. We delegate authorities to protect those God-given rights. We are the boss. We are the master. The government, the servant. God, the giver of life and rights. This is largely ignored today, of course. The state, the federal government comes in and we think, oh, there's a badge. Oh, we need to obey. Not necessarily. I encourage any of you that are taking this class right now, if you run for public office, protect your people. Protect them against federal tyranny, state tyranny. Protect your constituency. That is your job. That is the oath that you swore. The new Bill of Rights. Now, many people say, okay, that's great, Jake. That sounds awesome. Listen to this Bill of Rights. We should be free, man. What happened? How in the world did they get flipped on their heads? It clearly limits the federal power. I've explained how to, and I've done my best to. I want to speak to you on this topic because it's important. This was in 1944, okay? Before we had radical, loony leftists, if you will. Many of you maybe have just gotten involved in the political system here recently. You've been following what your congressmen and things like that have been doing, and I applaud you for that. but this has been going on for a while. Remember, the devil has existed since the beginning of quote-unquote time on earth. Therefore, he's always been at war with God. He's always been at war with God's people. He's always been at war with the rights of those people. FDR said in 1944 in his annual address to Congress, picture this. This is lunatic. Listen to what he said. The one supreme objective for the future can be summed up in one word. Security. Security. This republic had its beginning and grew to its present strength under the protection of certain inalienable rights. Among them, the right to freedom of speech, freedom of press, freedom of worship, trial by jury, freedom from unreasonable searches and seizures. Good for you. Good for you, FDR. They were our rights to life and liberty. As our nation has grown in size and stature, we've evolved. However, as our industrial economy expanded, these political rights proved inadequate to assure us equality in the pursuit of happiness. It's kind of an arbitrary term. What does that mean? Pursuit of happiness. Who determines if I'm happy? Well, I do. So to speak, a second Bill of Rights under which a new basis of security and prosperity can be established for all. Among these, this is his new Bill of Rights, 1944, people. We've accepted the right to a useful and remunerative job. That's not a God-given right. As a matter of fact, the contrary of that. The government commands you to work. It's not God-given. And as a matter of fact, the only way I can have the right to a job is if by force it's taken from somebody else. It's the only way the government can give me a job. Or force an employer to hire me, right? Non-discrimination. The right to earn enough to provide adequate food and clothing and recreation, said FDR. That's not a God-given right. You have the opportunity to do these things. If my God-given rights are protected, I will be able to do these things. But now it's taking it a step further. The right of every family to a decent home. Oh yeah, the government's doing a great job of providing for housing, aren't they? I live kind of near an area just south of D.C. where Section 8 housing has moved in. And you can literally tell. Government provides the homes, guess what happens? The right to adequate medical care. See, this isn't even Obama. This is in the 40s. Prior to that, it was Harry Truman. Or excuse me, actually after that was Harry Truman. The right to adequate protection from the economic fears of old age, sickness, accident, and unemployment. There's your Social Security. The right to a good education. All these rights spell security. No, what they spell is tyranny. There's only one way for us to accomplish all of those things. There's only one way for the government to accomplish all of those things. That's through tyranny. Everything he's identified right here has to be taken from somebody else to be given to you. Everything. FDR's unconstitutional agenda has been increasingly implemented. You didn't even know this existed. I'm sure of it, many of you. You did not know this existed. I about fell off my chair the first time I read this. This has been the playbook. Even today, we face federal government taking over health care of every citizen. Aggrandizing federal power. Aggrandizing. It's a parasite. It's a parasite. The economy of government is parasitical by nature. It has to suck off of us in order to do anything because it can't grow itself. It can't get involved in private enterprise. So as a review of our Bill of Rights, as we contrast them with what FDR said, as we contrast them with the Communist Manifesto, as Chris pointed out for us today, says, as we contrast it with what the Bill of Rights says. First Amendment is the freedom of religion. Second Amendment, keep and bear arms. Third Amendment, my home is my castle. There's no quartering of people, no by force. Fourth is no warrant, no search. Fifth, personal and property rights. The sixth, Criminal defendants, their rights. It's criminal defendants. Notice I said defendants. Defending themselves against criminal accusations. Number 7, in criminal cases, just clarifying criminal cases. Number 8, when punished, what are the confines or what are the boundaries of your punishment? Number 9, unenumerated rights. And number 10, undelegated powers. So review those 2 and let's look at our homework. Our homework is the Interposition DVD. Please, 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 I encourage you to get it. Go to theamericanview.com and get that DVD. As a matter of fact, you can buy the homework DVDs. If anybody wants all the homework, the DVDs, and the supplemental stuff on all the homework from all the lectures, forgive me, I haven't offered this before, but we're doing a sale on all of those articles, and you can get those for, I believe it's $60. Normally it's close to $100. I think it's $95, but we're axing that. You all have paid to take this course. We appreciate you. This isn't an issue of money to us. It's an issue of saving our country. So if you want to get these, you can get them in the package. Otherwise, you can buy them individually as you want. To understand the vital role the lesser magistrates are under oath to play in protecting the citizen from a higher magistrate who is violating the law of God. We also have the sheriff's course now. He's the executive officer of your local government. We've been having tremendous success with that all across the country. I hope you're all encouraged tonight by what you've learned. Let's apply it, and may God bless you. Have a great evening. If there's any questions, please send those through. If not, I'm going to check out and get this link ready so that I can send it off to all of you. Thank you. God bless you. Have a great night.